Hi there, it's Wendy Hernandez with Command the Courtroom. And in this week's video, I want to talk with you about this notion of unreasonably withholding consent. I bring this up because I see it come up again and again in my cases. And I saw it come up recently in one of my cases where the father in the situation wanted to take the party's child to Disneyland during a weekend when the father's parents were coming from out of state just so they could all travel to California and go to Disneyland. In this particular situation, my client didn't give father an answer about Disneyland for days, and he was asking her via an email and text, can we go, can we go, can we go? And she was addressing other matters, and she was trying to get other things from father, related to other situations they had going on, but she would not address this Disneyland issue. And in my mind, mother's failure to address this issue promptly was the unreasonable withholding of consent. And ultimately, she did say yes. She said yes like the day before the trip was supposed to happen. In my mind, if mother didn't have any plans that she could have changed, the answer should have been an immediate and a simple yes, because that was best for the party's child. I see the unreasonable withholding of consent come up in situations where one parent wants to travel to another state or another country even over the holidays. And one parent won't sign for the paperwork, that you need to show the airline authorizing the other parent to travel with the child. And again, if the parenting plan allows for both parties to have a vacation and it allows for both parties to travel to another state or country, then not signing what needs to be signed amounts to the unreasonable withholding of consent. In the case that I was referring to with respect to the Disneyland situation, normally the party's daughter was in daycare all day. And there was a period of time when mother's family came from out of the country and they wanted to spend time with their granddaughter while she would have been in daycare. Well, during father's time, he disallowed this contact between the daughter and the grandparents. So essentially the grandparents who were here from another country to visit their granddaughter just sat in an apartment all day while the little girl was in daycare. And, it's not like she was in kindergarten or first grade or even preschool where she was missing out on work. She was in daycare. So that is another example of the unreasonable withholding of consent. Now, there might be some situations where a parent asks you for a concession or a favor, and you may have other plans already made that cannot be changed. And if that is the case, then that saying no to that would not be the unreasonable withholding of consent. But I would just ask you to be careful and be mindful of when somebody asks for a favor, the other parent asks for a favor, and you aren't giving an answer quickly, or you're not giving an answer that is reasonable. Because if you do end up in court, one of the things that the judge is going to look at is which party is the party that's more likely to allow continuing and consistent access to the child. And if you're a person, if you're the party who's unreasonably withheld consent, then the judge may find that you're not that parent, and that could be a strike against you in the overall custody battle. So I hope that little tip helped. Remember to subscribe to the Command the Courtroom channel on YouTube. If you like this video, give it a thumbs up. Like us on Facebook. Send me any questions that you have. I may feature the question in a future video. But until next week, keep on trucking. And remember to command the courtroom.